In a contested divorce case in New York, when and how does discovery begin?
Discovery really should begin even before you hit the preliminary conference. The parties should exchange and file with the court what's called a net worth statement, and that can be found on the court's website. That net worth statement is going to be a preliminary disclosure of one's income, expenses, assets, and debt. When you hit the preliminary conference, the court will order mandatory disclosure. Mandatory disclosure is 3 years worth of bank account statements, tax returns, investment account statements, retirement statements, as well as any debt statements be exchanged. Usually if that exchange has not already taken place, then the court will give 30 days. I've seen some orders where they extend it to 45, but that's the general time frame on exchange of mandatory disclosure. So I oftentimes advise clients when they get the preliminary conference order in, and they usually receive that order about a month or so before the preliminary conference takes place, that they should already begin to gather those documents. And that way they can kind of be given an extra month. And that way they'll have 2 months to get those documents together to actually make that exchange. Now, there's other disclosure deadlines that are set up within the preliminary conference order. So in most cases, not all, but in most cases, there is what's called a discovery and inspection demand. So that will be a further request for documents other than just the mandatory disclosure documents that I just mentioned. The courts also allow the attorneys to exchange demands for interrogatories, and basically those are just a list of questions that somebody has to answer. Generally speaking, they're limited to 25 questions, and they really should be good questions for clarification, particularly on the financial issues that are involved in either child support, maintenance, and or equitable distribution of assets. Generally speaking, especially in the courts downstate, they do not allow disclosure on custody and visitation issues except by permission of the court. That's a different rule than exists upstate. So in upstate courts, they do generally allow disclosure on custody and visitation issues. The court will also set up a deposition deadline. So depositions are where either attorney can ask questions of clarification with a court reporter present in his or her conference room. And the aim of that is to clarify any information, gaps of information that exist in the disclosure of documents, as well as the answers to interrogatories. I usually advise my clients and recommend to them that they answer the interrogatories as completely as possible, simply because then that limits the time they have to spend at the deposition. If you've already answered a question in the interrogatory, it would kind of be silly for the opposing attorney to ask the same question at the deposition. It would kind of be a waste of everyone's time since you've already given a sworn response in the interrogatory. But that would, generally speaking, be the disclosure schedule that would be set up at the preliminary conference.